Hi, my name is Nadav Ravid. I am the managing partner of Ravid Law Group. Our firm specializes in representing landlords and tenants in negotiating their commercial real estate leases throughout the country. Each month, our firm publishes a DIRT report, which analyzes various cases and laws throughout the country that are addressing various issues related to leases. And in the past year, we've been covering a lot of cases that have tried to address the big question that everyone has of whether or not rent is still due in light of the COVID-19 pandemic. And early on, it looked like a lot of courts were siding with the landlords, holding that basically the force majeure provisions of the leases, which held that in the event that a circumstance that is beyond the parties' control arises, then yes, the parties will be excused from performing. For example, a restaurant doesn't have to stay open and operate, but the language of the force majeure provision went on to say that in no event will the tenant be excused from paying rent. And that seemed to carry the day. In the early cases, a lot of conventional wisdom was that that would be a very strong argument for landlords. But as we've seen over the last several months, there have been some cases that have come down on the tenant side, and tenants basically responded to the force majeure argument and said that, well, there are these legal principles outside of the contract, outside of the lease, that are referred to as the frustration of purpose and the doctrine of impossibility, and that those legal principles, notwithstanding the language of the lease, should support a tenant's position that the rent should not be due. And basically the argument goes as follows, that I signed a contract that contemplated that I would operate as a retail store or that would operate as a restaurant, and then COVID-19 occurred, which rendered my ability to operate or perform impossible, or it basically frustrated the entire purpose of this contract. We would have never signed this contract had we been able to anticipate that something like COVID-19 would occur. And because of the impossibility or the frustration of purpose, some tenants argued that they were entitled to completely terminate their leases, avoid all of their rent, even beyond the pandemic. And other tenants, or at least at a minimum, they argued that the rent should not be due during the period of time that they were prevented from operating, or at least, again, they were subject to severe restrictions on their ability to operate. And so some cases did come down helping the tenants and saying that at least during the period of time when, for example, there was a government order that prevented any operation, that the tenants were entitled to some rent relief. Not necessarily 100%, but some percentage of relief. So there was one case out of Chicago that said, there was a bankruptcy case that said that a restaurant tenant that could only do takeout was responsible for roughly about 25% of the rent. There was a retail case, the Gap case, where the landlords, they were very happy with the outcome because the Gap was ordered to pay 90% of the rent. We're talking about Times Square space in New York, where the rent was, I believe it was $3 million a month. So in the court preliminarily said, yes, tenant, you still have to pay the rent, but we'll give you on a temporary basis, a 10% discount. So the court acknowledged that there was some reduction in rent that the tenant might be entitled to. But we haven't seen a case come down to say that 100% of the rent should be excused during the time of the shutdown, until this case that just came down a few months ago, dealing with a restaurant called Caffé Nero out of Boston, Massachusetts. And in that case, the tenant restaurant was operating. COVID-19 hit. The tenant shut down, stopped paying rent. They tried to work out some kind of a compromise, some kind of a settlement with the landlord to pay some function, some formula based on percentage of sales. But the landlord refused. The landlord said nope. They couldn't come up with an agreement, and the tenant basically stopped paying rent and shut down the restaurant. And the landlord sued to terminate the lease and to recover all of the rent that was due for the entire term. And the tenant made, the same arguments that you see other tenants making, which was that the force majeure, notwithstanding the force majeure provision of that lease, that the doctrine of impossibility and frustration of purpose defenses should apply, and therefore the tenant's rent should be completely excused, and the tenant should be completely relieved of all of its obligations. And the landlord countered and said, well, based on the force majeure provision, the tenant should not be entitled to any relief. And the force majeure provision in this particular case is a very common one that we probably is the most familiar, contains the most familiar type of language that we see in a lot of leases, which basically said that in the event some event occurs that was unforeseen, or I should say some event outside of the party's reasonable control, such as some tornado, casualty, earthquake, or a government order that prevents you from operating. That's really the one that was implicated in this case. Then the tenant is excused from performing their obligations under the lease, except for rent, except for money. The tenant could not use the force majeure provision to excuse itself from the obligation to pay money. And that's the argument that the landlord raised. And the court said, well, we believe the way this language is written, that it's really intended to cover what should happen in the event that performance is rendered impossible. Because it says if the tenant is prevented from operating by a government order, which was the case here. The tenant was prevented from operating as a restaurant for at least 2 to 3 months. And the court said that if that was all that we were contemplating, whether or not the performance was impossible, then maybe we would agree with you, landlord, that the tenant should not be excused from paying rent. Well, first of all, it said maybe we would agree with you, landlord, because this concept of impossibility would be implicated, and therefore this provision said that, yes, you're only excused from some obligations, but not the obligation to pay rent. But the court also said that it wasn't even impossible to pay the rent. You know, the tenant could still pay the rent, so the tenant couldn't argue that that performance was prevented by some force majeure event. But nevertheless, the court focused on the fact that this force majeure provision did not help the landlord because it didn't contemplate what would happen in the event the performance is still possible, like for example, paying rent, but the main purpose of the contract was frustrated. The whole purpose of this contract was for the tenant to operate a restaurant. And that main purpose of the contract was rendered destroyed as a result of the COVID-19, at least during the period of time when there was a government order that said, tenant, you are not permitted to operate to allow for indoor dining, which was the purpose of this contract. And so because of that, the court said they're going to apply the frustration of purpose defense during the period of the shutdown order, and said that during that period of time, this tenant, this restaurant tenant, was excused from paying 100% of the rent. So that's big news for tenants. That's really positive news for a lot of restaurant tenants, especially, who could go back to their landlords, especially in Massachusetts, and take the position that none of their rent during the period of time from March till June, when the government said that no indoor dining was permitted. And that's going to be interesting to see how that line of thinking, that reasoning, will be used perhaps in other jurisdictions. Again, there have been other jurisdictions faced with very similar issues that have rejected that position. And so we'll see whether or not other courts follow this court, or whether or not they follow these other cases where they ruled in favor of the landlord, notwithstanding the fact that this court tried to make a distinction between these two defenses of impossibility and frustration of purpose. So we will keep monitoring these cases throughout the country, and we will keep you updated. Thank you.